It's 9 o'clock. Good morning, everyone. Thank you for joining us for the Medical Board of California's Panel A meeting. Pursuant to the provision of Governor Gavin Newsom's Executive Order N29-20, dated March 17, 2020, this meeting is being conducted via WebEx. Panel A Chair Dr. Lewis, you can officially begin the meeting.
Hey, good morning, everyone. This is Dr. Ron Lewis, Chair of Panel A of the Medical Board of California. This meeting is called to order. Please call the roll.
Dr. Lewis.
Present.
Dr. Hawkins.
Oops.
Ms. Lubiano.
What's wrong with this damn thing?
Present. Dr. Tirado.
Present.
Mr. Watkins.
Present.
And Dr. Yip.
Present.
We have a quorum.
We have a quorum. And
It's weird.
I will now turn the meeting over to the ALJ, Tiffany King, for further comments and to begin the meeting.
Okay, good morning, everyone. Before we go on the record, I did just want to ensure that Dr. Khan is present and on the line.
Let me go ahead and promote him. And Mr. Khan, can you come off mute and let us know that you're there?
Yeah, I'm here.
Okay, and then I also have Greg Chambers here. Greg, could you come off mute and let us know that you're there?
Come here, Sean.
Okay, Judge King, I believe that's all the involved parties.
Okay, thank you very much.
Before we continue, Judge King, this is a court reporter. I apologize for interrupting. Sean, am I able to be upgraded as a panelist?
You are a panelist, right?
Okay.
So you can mute and unmute yourself now as you like.
Right. I'm also connected to my computer, and I'm trying to find a way to share my video and mute and unmute on my computer also.
Oh, okay. I didn't know you were using that second account. Let me upgrade that one as well, just a sec.
Oh, okay. I apologize for that.
Okay, both should be in the panelist role now.
Very good. Judge King, can you hear me okay?
I can hear you just fine, Ryan.
Lovely. Thank you very much, Sean.
Okay, are we ready to go then, Ryan?
Yeah.
We are?
I am ready to go.
All right, then let's go ahead and go on the record. Good morning, everyone. We are on the record before Panel A of the Medical Board of California in the matter of the statement of issues against Sher Ali Khan. This is board case number 800, 2019 060510. The OAH case number is 2020 100 459. Today is November 12, 2020. The time is approximately 9 a.m. and this hearing is being conducted via video conference. This is the date, time, and place set for oral argument in the notice of hearing for oral argument. My name is Tiffany King. I am an administrative law judge with the Office of Administrative Hearings, and I've been assigned to preside over this hearing. Prior to going on the record, the board members did identify themselves and a quorum was established. If I could please take the appearance of counsel, Mr. Chambers.
Greg Chambers with the Attorney General's Office representing complainants.
Thank you. And Dr. Khan, I will note for the record that you are present and representing yourself. Is that correct?
That's correct.
And were you previously advised you could have retained counsel to represent you?
Yes.
Okay, thank you. In this matter, the board has issued an order of non-adoption of a proposed decision by an ALJ and is determined to decide the matter itself. The board has invited particular discussion on whether the proposed order should be modified. The following process and time limitations will apply. Respondent will have 15 minutes to make an opening argument. Mr. Chambers will then have 15 minutes for a response. Respondent will have 5 minutes for closing argument, and then Mr. Chambers will have 5 minutes for closing. So we are on video, and what I intend to do is I will mute myself, but with about 1 minute left in your time period, I will unmute myself and give you a 1 minute warning. Please be advised that the argument should be based on the existing record only and should not exceed the scope of the record of the admitted evidence. No new evidence will be heard or received today. Panel members may ask questions of the party if they want to clarify any arguments, but they may not ask any questions which would elicit new evidence. At the end of oral arguments by both sides, I will offer the respondent an opportunity to address the panel directly regarding the penalty. And if he elects to do so, then he will be placed under oath before doing that. After oral argument, the board will go into closed session to deliberate. The parties will not receive a decision today, but will receive it in the mail sometime in the future. Are there any questions before we begin?
No.
Okay.
Judge King, this is Sean from the medical board staff. If I could ask that, everyone that's involved, unless you're speaking, don't just leave your mic open. It's picking up a lot of background noise and making it difficult for everyone else to hear. So if everyone could mute and just come off mute if you need to, and then go back on and off, that'll make it a lot clearer for everyone else. Thank you.
Okay, thank you. And with that, Dr. Khan, I'll turn it over to you and your 15 minutes begin now.
Thank you so much, Your Honor. So I'll begin with the statement which Mr. Chambers had written in his last written argument. He mentioned that I did not disclose my condition bipolar in when I applied to the California medical license to start with, and he mentioned that I did not disclose, and that's why I should, even if I'm being given the probation, it should be 3 years, it should be 5 years. That's where
I apologize. This is a court reporter. Judge King, I'm going to take us off the record. John, there seems to be a little bit of background noise. Are we able to focus in on where that's coming from, or if that's coming from the respondent?
I don't have any noise here. I'm in a lone room. And
okay. Judge King, when the respondent just spoke, did you hear any background noise?
I did hear some background. I'm wondering, Dr. Khan, are you able to lean into your microphone a little bit closer?
Well, what I can do is I can wear the headphone. Let me arrange my headphone one second.
Okay.
Okay. I apologize, Judge King.
Ryan, it does appear that everybody is on mute. I mean, I came off mute just now just to talk with you, but.
Okay, it just seems that when the respondent is talking that there seems to be...
I hear it as well.
Yeah.
Can you hear me?
Hi, sir. I can hear you now. Can you just give me a microphone check, please?
Hello, can you hear me? This is the test.
Okay. Yeah, that sounds a lot better.
Any
Thank
noise
you very
this
much.
time? Okay. Well, thanks for pointing out, Ryan. So,
okay, so hold on a second, Dr. Khan. Okay, so Ryan, are we ready to go back on the record?
I'm good to go. Thank you, sir.
Okay, let's go back on the record.
Okay. Sure. So, Your Honor, I was mentioning that Greg Chambers mentioned in his written argument that I did not disclose my bipolar, and that's why I should be granted extended probation, if any, even if I'm considered for the license. That's his main argument was surrounding the bipolar. So my answer to that is that, first of all, my bipolar has been refuted by the psychiatrists in United States. They are saying that most likely I do not have bipolar, and it's the symptoms of ADHD, which is attention deficit hyperactivity disorder, which have been confused by the previous psychiatrist, which was in Pakistan. So in Pakistan, the psychiatrists still believe that an adult should not have ADHD. When the kids become adult, when they cross 12, after 12 years of age, or after 15 or 18 maximum years of age, they grow out of the ADHD, and the ADHD is not an adult issue. But predominant research has proven, and the DSM-5 criteria says that there is an entity in the adults, which is adult ADHD. So in the third world countries, they still say that, okay, these symptoms of hyperactivity or inattention are bipolar. So they diagnosed me with bipolar in Pakistan. And when I came to the United States, the physicians said that, no, it's not the bipolar. So very take it off my record, and my psychiatrist will issue me a letter that that's first point. Second point, why I did not disclose this thing, that there is a chance or there is a record of bipolar. When I applied to the license for the California license, it asks, the California license application asks that, do you have any condition, a mental condition which will affect your ability to work as a physician? So it has been proven that my current conditions do not affect my ability to work. Even if I have bipolar, that is not affecting my ability to work. Hence, it was prudent to not mention this in the license application. I'm very sure there must be judges, there must be lawyers, and there must be doctors who have mental conditions. Mental conditions are as common as physical conditions, and they are not supposed to mention all of their conditions in the application to the state licenses if they believe and they have evidence that those conditions are not affecting their ability to work. I'm sure the audience which is listening to me right now, many of them might have the mental conditions. Some of them might have OCD, some might have ADHD, some might have bipolar even, but they have not mentioned them in the applications because they believe and they have the evidence that that does not affect their ability to work. And my paperwork, which I have already submitted to you guys and to the administrative law judge in the past, has the paperwork from the psychiatrist and from the psychologist, which do not bring up any concern regarding my bipolar affecting the work. So that evidence has already been given to you guys. So first of all, there is no bipolar. Even if there is, that is not affecting my work. That's why I did not bring it up. That's my argument regarding the bipolar. The second thing is that there is an update which has not been yet communicated to the administrative law judge, is that I have started my public health and preventive medicine residency in University of New Mexico. In my previous hearing, I attended the hearing with the California administrative law judge from Pakistan, and I was waiting for my visa to start my residency at University of New Mexico. At that time, I did not have visas, and that administrative law judge, she had written in her proposed decision that I have secured a residency in University of New Mexico, but I have not started it because I don't have visa. So there's an update. I started my residency. I completed 1 month. So my request for the administrative law judge and for the panel A is that please wait for my residency to complete, the residency at University of New Mexico. If I complete this residency with satisfactory evaluation, I should be granted the unrestricted license, medical license to work in California. But if I do not complete this residency with satisfaction, or I do not even complete it, that will support the fact that I had problems with my previous residency. Then you might reject the license. You might not want to give me the license. So if I complete this residency, that means the satisfactory evaluation which I got from my previous residency, that's true. It will support that satisfactory evaluation which I got from my previous residency. So that's the second thing I wanted to share with you guys. The first thing was bipolar. The second thing is UNM residency. The third thing, there is an evaluation which I submitted to you guys, and that is known as the summative evaluation of the residency. So when a resident graduates from any residency program, he gets a summative evaluation, the final evaluation from the program director, and that comes from the program director, and it represents the whole clinical competence committee, which is known as the CCC of the residency. And that evaluation says that I completed 2 years of residency with satisfactory evaluation in the 6 competencies of ACGME. So that is enough of a proof that my residency was completed with satisfaction. That, as per ACGME guidelines, that is the final document which will say yes or no about if a resident has completed the residency with satisfaction or not. When I came to the University of when I applied to the University of New Mexico for my residency, they asked for 2 documents. One was a letter of recommendation from my program director that he recommends me that this is a good residency for me, this is a good career for me. And I provided that. And I have provided that letter of recommendation to you guys too, where my program director says that I completed my residency with satisfaction, and I was very professional. I had good performance. I'm intelligent, perseverance, good with the patients. Everything is there. The second document which they wanted from me was a satisfactory evaluation in the summative evaluation, which comprises 6 clinical competencies as outlined by the ACGME. And they provided me that. And I have provided you guys too. And that's why I started my residency in New Mexico. Without these 2 documents, I would not have started that. So this is enough of a proof, this evaluation, the summative evaluation, that I completed my residency with satisfaction. It was declared satisfactory. A resident has good or bad evaluations from during the residency. But all it matters is the final evaluation, which is yes or no. In my case, the good evaluations throughout the residency outweighed the bad evaluations, and that's why I got the satisfactory evaluation in the summative evaluation document, which I have provided to you guys. So, and if I'm discriminated based on the ADHD, if the panel says that no, we cannot give you the license, we cannot give you unrestricted license, even though you brought the full satisfactory evaluation from the previous residency, and even if you bring the satisfactory evaluation from the current residency, I would say that that's a discrimination based on my disability. So I don't know what kind of evidence would the panel need to prove that I'm capable of being an independent physician. Just because I have a disability of ADHD, that doesn't mean that I should get probation. I have proven in my previous residency that I'm capable. I got my evaluations, the final good satisfactory evaluation, and I'll prove that again in my new residency. And I think that should be enough of a proof that I'm capable, even though I have the disability. And this disability.
Dr. Khan, you have 1 minute left.
Okay, thank you so much, Your Honor. So I think my disability gives me strength to address those patients who have the disabilities, to take care of them better than those people who do not have the disability. So I can consider their problems better because I've been through those problems. I think that's all I have to say.
Thank you very much. Mr. Chambers, are you ready?
Yes.
Okay, your time begins now.
This is a straightforward case. The evidence established that because of the applicant's lack of medical knowledge, the applicant was not allowed to complete his third year of residency. And he failed to inform the board when he applied for licensure that he had been diagnosed with bipolar II disorder. Now, contrary to the applicant's claims today that he completed the residency satisfactorily, he didn't. They terminated him before he could finish his third year. So if the applicant is to be granted a probationary license, the 5-year term referenced by the administrative law judge should be at the very minimum coupled with terms and conditions that assure the public safety during the probationary period. An applicant seeking licensure has the burden of showing that he meets the requirements for licensure and is safe to practice. The applicant has not shown that he's safe to practice without supervision up to this juncture. And the idea that we would take the word of a residency program in New Mexico that he's just started, that doesn't fly with the guidelines for the state of California. The board's expert, Dr. James Nuovo, formerly of the UC Davis Medical Schools, is an individual who's appeared before this panel and this board for a number of years regarding the board's credentialing of medical schools. His expertise of medicine and medical schools and programs is well known. Dr. Nuovo noted in his testimony and in his report that was presented as evidence that while the applicant appeared to have improved towards the end of his second year of residency, the deficiencies identified during the first 2 years of the residency included, quote, well, 1, medical knowledge, 2, the application of his medical knowledge to patient care, 3, obtaining reliable, accurate patient history information and test results, 4, the ability to generate a differential diagnosis, and 5, prioritizing management of patient problems. Dr. Nuovo also noted concerns about the applicant's ability to have insight into those aforementioned deficiencies. And this is where we loop back into the issue with regard to the bipolar diagnosis. The applicant testified today that he doesn't have a problem with bipolar II diagnosis, and because of that, he didn't have to declare on his application. I would direct you all to Exhibit 2, which is Bates page A33, questions 48 and 49. 48 said, have you ever been diagnosed with an emotional, mental, or behavioral disorder that may impair your ability to practice medicine safely? Not that has, but may impair. We've had a number of cases with bipolar disorder 1 and 2 come before this board. We have had problems with bipolar disorder. These people, these individuals, when properly treated, do a great job of becoming, functioning and respected members of the medical society. And the idea that one would not want to address this issue beforehand is kind of disturbing. And it comes back to the issue of that Dr. Nuovo raised, which was having an insight into the aforementioned deficiencies. Ultimately, Dr. Nuovo opined that the applicant should not be granted an unrestricted license, and no evidence was presented to overcome that opinion. Now, let's discuss the bipolar II disorder. When the applicant submitted that request for license, he ignored 48 and 49. In subsequent filings with this panel, we learned about that, but it wasn't until after the hearing date was set. So presently, we have only the documents that were presented at the hearing. We have no idea if, in fact, there was a misdiagnosis, or, in fact, the diagnosis coming out of Pakistan was, in fact, correct. We don't know. That evidence has never been presented. So until the applicant provides that information to this board, we have to take the board's primary mandate, which is protect the public. That has to come first and foremost. Now, there was an argument that was raised about discrimination if there's any sort of decision involving his disability, which then implicates the American for Disabilities Act of 1990, which can be found at 42 USC sections 12-101 et sec. Now, with the ADA, discrimination occurs when a panel such as this does not make reasonable accommodations to the known physical or mental limitations of an otherwise qualified individual with a disability. That can be found at 42 USC section 12-112, subsection B, subsection 5, subsection A. Now, the board's decision can properly carve out a reasonable and reasoned accommodation to allow the petitioner to practice medicine and retain a probationary license in a manner that ensures he is qualified and capable to safely practice. At this juncture, we don't know that he's safe to practice because we don't have a full evaluation of the physician. So if there's going to be any sort of probationary license, there has to be a carve out in which there's a medical evaluation and diagnosis presented to this board so that we can determine that he is in fact safe to practice. The law would not require licensure or continued licensure. If doing so would be inconsistent with public safety. And the ADA contemplates that there may be terms and conditions designed to ameliorate the risk of any possible harm. A board's decision that is carefully crafted to ensure that over a period of time that this applicant will receive the treatment and medication that is necessary to stabilize his condition so that he can safely practice does not run afoul of the ADA. And this is an issue that we've had to deal with before with regard to mental health issues for licensees. So, in light of the aforementioned, if the board determines that a probationary license is even viable, there will need to be greater structure than the ALJ's proposed decision. This would include, it would need to include at least more than an evaluation, such as term 20 of the disciplinary manual, term 21 of the disciplinary manual, which is psychotherapy, and term 22, which would be medical evaluation and treatment. If in fact the probationary license is even considered, those would be at a minimum to be added to the ALJ's proposed decision. Thank you for your time.
Thank you, Mr. Chambers. Dr. Khan, you have 5 minutes for a closing in your time. Are you there, Dr. Khan?
Yeah, I'm here, Dr.
Okay, your time begins now.
So a couple of things mentioned by Greg. The first thing he mentioned was the lack of medical knowledge. As I said that I have already provided the summative evaluation to the committee and to the ALJ in the previous hearing. That summative evaluation has one of the 6 competencies of ACGME is medical knowledge. I have been declared satisfactory in all 6 of competencies, including medical knowledge. He mentioned Dr. Novovo's concerns over my lack of medical knowledge, application of the medical knowledge, prioritization. All of them are included in those 6 ACGME competencies, which are included in summative evaluation, and I've been declared satisfactory. Unfortunately, Dr. Novovo never considered or never asked to obtain the summative evaluation from my program. He did obtain the evaluations from individual mentors, which were during the residency. But ACGME mandates that the final evaluation, which is the summative evaluation, is the final word. He never asked for that. I'm concerned that Dr. Novovo might not be aware of the latest ACGME guidelines, which mandates to consider summative evaluation as the final evaluation. The third thing which Mr. Chambers mentioned was that I did not complete the residency. I was terminated. I completed 2 years of residency. At that juncture, I was told that I should not be promoted to the 3rd year, which is the final year of the residency, because my program director said my strengths do not match with the internal medicine. I should go for a residency which is mainly outpatient and which is research oriented or public health oriented. So I did that. He gave me the satisfactory evaluation for the 2 years performance. He did not terminate me. He did not terminate my contract. So this word of termination never applies to me. I was not promoted to the 2nd, 3rd year. I completed 2 years and I applied to the next residency, which my program director recommended, which is public health, preventive medicine, mainly outpatient. And I want to complete that. Mr. Chambers mentioned that we cannot take the word of the University of New Mexico. Yes, at this point you cannot, because I just started the residency. But if I complete the residency at University of New Mexico with satisfaction, I think that is something. Mr. Chamber also mentioned that there is lack of documentation from Pakistan. I can certainly provide the documentation from Pakistan. I have it with me. If administrative law judge asks me, I can provide that. And I can also additionally produce more documentation from the psychologist mentioning that I'm safe to work. There is no harm from me. I can provide that. He mentioned psychotherapy. While I was doing residency in Chicago for 2 years, I consistently got psychotherapy and it was good. And I got letters from psychotherapists. Everything was going well. So I have been up to date on my medication. I've been up to date on my psychotherapy. There is no suspicion of harm to the people from me. And there will be no evidence that I might have harmed a patient in the residency.
Dr. Khan, you have 1 minute.
Thank you, Your Honor. I clarified the medical knowledge part. I'm satisfactory on that. Mr. Novova never considered the summative evaluation. I hope the panel A and administrative law judge considers the summative evaluation for the 2 years. And in 2019, the law of California, which surrounds the provision of unrestricted license, it required satisfactory completion of 2 years of residency. And I completed 2 years of residency with satisfaction, and that's why I applied to the medical license of California. Otherwise, if they required the full completion of the residency, I would never have applied. Similarly, Ohio required 2 years, and they gave me the license because they required 2 years. I think that's about it.
Thank you. Mr. Chambers, you have 5 minutes to present your closing. Your time begins now.
With regard to a singular document stating satisfactory completion of residency, we have an entire collection of evidence that has been presented to the board during the hearing that stated that the applicant's time in residency was not satisfactory. There was not 1, there was not 2, there was not 3, there was not 4, there was not 5, but more than 6 individuals who oversaw the applicant's education while in the residency, who all found that his work was not satisfactory. And this was not something that was missed by Dr. Nuovo, and in fact, he testified to that. The idea that the work was satisfactory is incorrect. So while the applicant is incredibly intelligent, there were problems in the residency, and that's why he didn't complete the residency. And that's why he's in New Mexico now. With regard to documentation that can arrive from Pakistan or elsewhere, that's documentation that should have been provided to the board at the outset, and it wasn't. And it wasn't until we started poking around the application and noting that the application was incorrect with regard to questions 48 and 49, which all comes back to Dr. Nuovo's concern that this applicant has trouble with insight into his deficiencies. Until that's determined to be untrue or incorrect or has been rectified, at this juncture, it would not be appropriate for this board to go under 5 years and for the probationary license, and it would be inappropriate to go with anything less than the structure that was presented earlier today if the applicant is even provided the opportunity to get a probationary license at this time. Thank you.
Thank you very much. At this time, I will check with the panel members if they have any questions. Dr. Lewis?
Yes, for Mr. Chambers. I have two questions. On on the application 48 and 49, could you read those or paraphrase those? And in what month and year did the respondent complete that application?
Yes, Dr. Lewis. So I will direct all parties to Exhibit 2, Bates page A33. It appears on the top of the page to have been electronically stamped as 5/1/2019 at 2:28 p.m. So quoting directly from question 48, quote, have you ever been diagnosed with an emotional, mental, or behavioral disorder that may impair your ability to practice medicine safely, close quote? Answer, no. Question 49, quote, have you ever been diagnosed with a neurological or other physical condition that may impair your ability to practice medicine safely, close quote? Answer, no.
And you are aware, I assume, that the board changed some of those questions in the not too distant past to reflect a little more broader question and not more punitive or specific, correct?
I'm aware there's been changes, but that's not what this applicant answered, sir.
Okay. Now, regarding the ALJ proposed decision, what are your actual objections to the proposed decision as you understand it? Because I get a little jargon and numbers and cases and all that. Just give me the idea of what your objections are to the current PD.
I would take at the minimum, I would take the current proposed decision. I would include term 20, which would be, that's a psychological evaluation, and term 21, which is required psychotherapy. Or I would add term 22, which is medical evaluation and required treatment based upon that medical evaluation.
So if I understand correctly, you would add 20, 21, and 22 to the current PD?
Correct, Your Honor. Or Dr. Lewis, I apologize.
Okay, yeah, that's right. I could be judged for today, so I appreciate that. Okay, anything else on the proposed decision that you would like altered or would accept? Since we're here to discuss the proposed decision.
I have nothing further, Dr. Lewis.
Okay, thank you. No further questions. Thank you, Your Honor.
Thank you. Dr. Yip, do you have any questions?
No, thank you.
Okay, thank you. Dr. Hawkins?
Yes, can you hear me?
Yes.
Okay, great. So Dr. Khan, question about, so I'm going to ask the DAG whether we can accept your letter, the CCC, I think it's called, because that was not available at the time we reviewed the information we had. My question is, why do you think there was such a range of evaluation, PGY1 and PGY2? Everyone said professionalism, courtesy, all that sort of stuff was great. But why do you think the evaluation was so wide range from not competent to excellent? That's my question. And I have a statement, and I would like to be corrected later if it's not correct. None of the disability is being based on a disability. None of your discipline is being based on the fact that you may or may not have ADHD or bipolar. That's not the basis. It's really clinical competence. So the question is, why the disparate range, PG1 and PGY2 in the evaluation? Thank you. That's my only question.
Okay. Your name is Dr. Hawkins?
Correct.
Okay. Thank you so much, Dr. Hawkins. That's a great question. So there was deficiency throughout the first year of my residency. There is no doubt in that. I was newly diagnosed with ADHD. My medications were shifted from the bipolar disorder, which was a wrong diagnosis, and that medications did not suit me, and I was transitioned to the what is it called, the ADHD medications. So it took me time to catch up with the contemporary residents, and that's why I was awarded 3 months extra time to catch up with my deficiency. So there are many evaluations which were not good, which had deficiency in the evaluation. But then I was promoted and I was declared that I have caught up with my contemporaries. And there are many, so when you check the trend in the second year, many evaluations significantly improved. And Dr. Novovo also witnessed that I significantly improved in the second year. If you see my 3 rotations in ICU, the first one had critical deficiency. The second one went towards the competent, and the third one went towards the exemplary evaluation. So the wide range of evaluation is because of that the first year I had deficiencies, and the second year I caught up with the deficiencies and I improved. But there are a couple of 3 or 4 evaluations out of maybe 5, 6, 7 evaluations in second year, which are saying that there are deficiencies. But Dr. Hawkins, those supervisors had bias towards me. At that time, the core clinical competence, the core clinical committee, they knew that I have bipolar. By second year, my program director disclosed it. He asked me, can he disclose my, not bipolar, the ADHD, can they disclose my ADHD to the core clinical competence committee? So I said, yeah, you can disclose. So he disclosed. So out of all the clinical competence committee, 2, 3 people, they were biased towards me. That's why they did not give me good evaluation. And that's why my program director says that, why don't you change the specialty? And Dr. Hawkins, you might have seen in your residency that sometimes the first impression is the last impression. Once you are declared good in the first few months of your residency, then you are a good man throughout the residency, even if you make mistakes. But if you are declared as deficient in the first few months of the residency, then the sticker is attached with your forehead that then some of the supervisors, they don't change their minds. You might have witnessed that in your residency too. So that's my answer. I hope that helps.
Yeah, thank you very much.
Thank you.
And Dr. Hawkins, you also had a question for Mr. Chambers, correct, regarding what evidence you're allowed to consider?
Yes. Yes, what evidence we can consider, rather, can we use that CCC assessment, the 6 core competency, which we're familiar with? And was there just clarification about whether any of Dr. Khan's disability, the discipline was related to his disability?
Mr. Chambers, would you like to respond?
So, Dr. Hawkins, from my perspective, I think I need to kick that over to Carrie Webb, because once the evidence is in, it's presented to you. So that's really outside of my purview, sir.
Understood. Thank you. What about the question of whether any of the discipline was related to his disability, which we are often very, very sensitive to?
I'm sorry, I missed the first part of it. You kind of cut out on me, sir.
Whether any of Dr. Khan's disability is related to whether any of Dr. Khan's discipline, is related to his disability.
I'm unaware of that. I'm only going based upon what's presented in the proposed decision by the ALJ, Your Honor, and I haven't had any ex parte communications with with that ALJ, so I can only take what's written within the four corners of that proposed decision. And quite frankly, the bipolar issue was really not raised during the hearing. It was something that documents were presented, but we did not discuss the bipolar diagnosis at any length during his testimony.
And of course, we would not acknowledge that the disability was used against him. Thank you.
It couldn't have been because we didn't discuss it.
Thank you very much. Thank you.
Thank you. Ms. Lubiano, do you have any questions? Ms. Lubiano, are you still on the line?
Can you hear me?
Yes. Did you have any questions, ma'am?
Yes, just a clarifying question for Dr. Khan. I saw that you saw in 2016, you were under the care of Dr. Gupta and Dr. Is it Dikis? I just wanted to confirm, was that was both here in the U.S.?
They were both in the U.S. Dr. Blodgett and Dr. Gupta, yes. Dr. Lubiano.
Got it. Thank you.
Okay.
Thank you. Dr. Tirado, do you have any questions?
No, thank you.
Thank you. And Mr. Watkins, any questions?
Thank you.
Okay. Any of the other panel members that had questions before, do you have any additional questions that maybe were generated by Dr. Khan or Mr. Chambers' response? Okay, hearing none, then at this time, Dr. Khan, I will give you an opportunity, if you would like, to address the panel regarding the penalty only. Would you like to do so? And if you would like to do so, I need to place you under oath first.
Sure, I would like to put a couple of requests to the panel.
Okay. In that event, if you could please raise your right hand. Do you solemnly state under penalty of perjury that the evidence you will give in this matter shall be the truth, the whole truth, and nothing but the truth?
That I will give the truth, but nothing other than truth.
Okay, thank you. Whenever you're ready, sir.
I'm ready. So my request to the panel A is that I'm happy that they all are doctors and they've been through the residency. Please consider the fact that good and bad evaluations are part of every resident's residency. And it's the summation of all the evaluations and it's the majority of the evaluations which make the decision. Like my majority of the evaluations are good, especially in the second year of the residency, based on which I got the summative evaluation. Summative evaluation is the most important evaluation. So please consider the fact, please consider summative evaluations, as well as consider the fact that every resident gets good or bad evaluations. It's the majority evaluations which makes the difference. The second thing is everyone with disability, they face these problems in the residency. And if you provide the opportunity to them, they do good. And it has been noted in the letters of my supervisors. I have provided the letters of recommendations, which were provided to me by my supervisors to go to the next job. There are 4 or 5 letters. All of them mentioned that I'm a very hardworking, ethical, professional, everything is good. That's the second thing. So please consider the predominant number of evaluations. Please consider the summative evaluation, and please consider the letters of recommendations which I got from my faculty, as well as from my program director. My program director has given me a very good letter to transition to the University of New Mexico, where he thinks I have a good chance to prosper in the field of public health. I have significant number of publications in the peer-reviewed journals, and I'm doing MPH right now, which is sponsored by the University of New Mexico. And I'm doing the preventive medicine residency, which is mainly outpatient. And I will continue my outpatient residency outpatient practice throughout my life, because my program director said that for me, keeping in view my disability, outpatient is good for me. So I'll do that. And please provide me the chance. Please provide me the unrestricted license. I will complete my University of New Mexico residency, and I will start my outpatient job. So just in one sentence, I want to say, please consider the majority of the evaluations which are good. Please consider the summative evaluation, which is the crux of all evaluations. Please consider the letters of recommendations, which I have provided, especially of program director and the core faculty member. And thank you so much for your time.
Thank you very much. All right, everyone, that does conclude oral arguments in this matter. The record is closed and the case is submitted. We can go off the record. And at this time, the panel will be deliberating in closed session. So this open session WebEx meeting will conclude, and the panel members should have been sent a separate link to join the closed session. So why don't we take it's 9:51 right now. Let's take a short break and we'll reconvene at 10 o'clock.
Judge King, this is a court reporter. Did you want the stop time and page count?
That would be wonderful. Thank you.
Thank you very much, Judge. I have official stop time of 9:51 a.m. with a page count of 27 pages.
Okay. Thank you, Ryan. And also, if you have an email, I can email you a copy of the agenda, which has all of the panel members' names on there with correct spellings.
That would be great, Your Honor. Email is sryan, that's SRYAN, 1987
Okay.
at gmail.com.
sryan1987@gmail.com.
Yes, ma'am.
Okay, I'll make sure that gets emailed to you by the end of the day. Thank you very much, Ryan.
Thank you, Judge. I am relieved of my duties and I will exit the meeting.
Okay. Dr. Lewis, I'll turn it back over to you.
Yes, now we will be shortly going into a closed session. As Judge King mentioned, we'll take about 10-minute break. And Sean, do you have further instructions for us or reminders about going into the closed session? Sean. Well, apparently the way it works is you'll exit this one, and in 10 minutes, you'll go back to the next email from WebEx, and you'll open that, and the word says closed on it. So we can all exit this meeting now. So, okay?
Okay, thank you very much.
Thank you, Judge. Appreciate your help.
Of course. See you in 10.
Bye. Now into open session. And now we're into close. Now we're adjourning the meeting. Panel A meeting is officially adjourned.
Thank you, Dr. Lewis. We'll see you this afternoon.
Okay, bye.
Have a good afternoon.
Thank you. Bye.
Bye.